Hi, I'm attorney Jason T. Brown, head of the whistleblower law firm Brown LLC, one of the most prolific law firms litigating whistleblower cases across the country. One of the most common questions we're asked during the intake process is, does the whistleblower need to be an employee? In short, the answer is no, with a footnote. It depends upon what statute you invoke to blow the whistle on to know whether or not you're eligible to become a whistleblower. One of the most common statutes navigated in the last decade was and is the False Claims Act. The False Claims Act involves when the federal government has been defrauded out of significant money. Under the False Claims Act, a whistleblower, also known as a relator, blows the whistle, brings the government to the case, the federal government, and if the government succeeds with the case, the whistleblower is eligible for up to 30% of what the government recovers as a whistleblower award. Nowhere in the statute does it indicate that the individual needs to be an employee. So the question then lingers about who else is eligible. Well, the answer is almost anybody can become a whistleblower, but back to the footnote. Other categories of people that typically blow the whistle are individuals in the healthcare space that are patients, but that's a very difficult road to travel. Individuals who are on the boards of the company, they're not technically employees. Consultants of the company, again, they may not be employees. And then from the outsider perspective, there is data miners and statistic hoarders that are able to cobble together the case through outside information. And ironically, there is another class of individuals that blow the whistle: competitors. Competitors like to blow the whistle, particularly in the customs fraud space, when they know that somebody is importing goods at a discounted rate, but the origin of goods has been concealed when in fact it was from China, but they drop shipped it to another country. So let me break down, since I used to be with the Department of Justice as a special agent and legal advisor with the FBI, and also this is a strong focus of our practice, whistleblowing, about what the real criteria is. And that is, the government's going to want to know at the end of the day, what sort of visibility did you have into the practice? And so, in short, how did you know that the illegal conduct was happening? And how insightful is your information? So just a low-level employee, and I'm not trying to marginalize anybody, but somebody who works for a major healthcare company and is at the bottom on the pyramid, let's say for argument's sake, the janitor. And the janitor may do great work at a huge nationwide healthcare company, but if he or she had information to blow the whistle, and they allege there's massive Medicaid fraud going for, let's say, for argument's sake, an opioid where the company is still prescribing opioids without prescriptions or circumventing the safeguards that were put into place to prohibit opioid dispensing without prescription or without supervision. The federal government's going to say, well, how did you know that? Did you lawfully access the information? Did you overhear board meetings in which they were talking about illegal conduct, or is it just some suspicion? So how do you know the information? So in contrast to somebody who's the janitor, and again, not to marginalize it, because a janitor could be a whistleblower, could have overheard significant conversations. What you can't do is illegally access information you weren't entitled to. But the higher up the chain, in the chain of command, in the employment world of a company, the more likely that individual is to have some degree of visibility about the unlawful practice. Somebody who's a director, somebody who's in charge of billing, somebody who's a CFO. The higher the position, the more likely the individual will have extensive information about the fraud, and the more instant credibility they generally get when the government is trying to evaluate the case. Now, other than employees, there's also, we talked about patients. We often get the fact pattern where patients call and say, hey, the doctor charged me for a neck brace, and I really don't need a neck brace. I just had a headache. Isn't this just some big scam? Yeah, it may very well be, But if we present that case to the federal government, how do we know that's happening to others and to what extent? So if you don't have that full visibility, it's a hard case to make, not impossible. You could take certain logical steps to put that case together. You could look online to see if other people were complaining about that they went in and no matter what they did, they received a neck brace. That they went in for hemorrhoids and they got a neck brace. And they had to pay a copay for something like that. So the more other information you can use to corroborate that it's happening, the better chance it is as an outsider, non-employee, that you could bring that case as a patient. From our firm's perspective, if you call us, that's some of the first questions we're going to ask. How do you know what happened to someone beyond you and to what extent? And if you can't answer those questions, it's going to be hard for the government to take the case. We're not going to take the case, although we may help you look online and look to other types of sources to try to cobble together the case. And when I say cobble together, that dovetails into the next area in which people sometimes file whistleblower cases, particularly under the False Claims Act, and that's data miners. Individuals that look for publicly available information or other information they can ascertain to try to cobble together a case. In the example for the neck braces that I just previously used, potentially, if that doctor is the number one prescriber of neck braces in the entire country, that may be another indicia that there's fraud. It may not. Somebody's got to be number one about something. But if all of a sudden multiple patients are complaining online that no matter what they come into the practice for, they get a neck brace, that doctor's the number one neck brace person in the country prescribing this product. Also, the doctor, let's throw in a Stark Law type of violation. The doctor owns the neck brace clinic, and somehow you could prove that from public records, which would be self-dealing, prohibitive type of sort of like a self-kickback. Then potentially you can put that case together. Data miners have been trying to put together a lot of PPP loan fraud cases. On ProPublica, there's information about what companies have received PPP loans, and it talks about their employee count, their census, if you will, as well as the revenue. And if individuals know, number one, that that's false, that they inflated their revenue, inflated their headcount from the inside, that's from either employee, you can take that case. But second, if you take that information that's publicly known in Area A on ProPublica and look and find, here's a corporate filing where they only claim they had 10 employees, not 500. Well, you might be onto something. And that could be a data mining type of case. Now, in the past, going back to a different stream of consciousness that we talked about, in which there's data miners, there's been entities who created corporations for the sole purpose of bringing False Claims Act litigation based on its data mining data that they discovered regarding propensities to overprescribe certain product or the top type of physicians in the field. We're not big fans of those cases unless there's some visibility that there's also some misconduct as well. You can't just have the indicia that where there's smoke, there's fire. You got to show us a little bit of the flame for us to take the case. And I think if you look at some of the opinions, there was some backlash to that. So we're very skeptical of filing, willing to listen, but it's got to be more, or it's got to be something concrete, where we use the PPP loan fraud example, where, okay, company Jay's Skyrocket Corp, and hopefully there's nothing named that, also owns Jay's Parachuting Corp and Jay's Ice Cream Corp, and it's all Jay, the same Jay, owning all three companies, and has 20,000 employees, and which well busted through the 500 cap with the interrelated companies. And they had a common nucleus of ownership, common management, things along those lines, and they shouldn't have received a loan in the first place. You could put that case together from the outside. You could maybe bring that False Claims Act case. Another area that we talk about that's a sneaky area is competitors. And believe me, competitors are out there. And competitors want to file these cases because they believe that the company committing the fraud is gaining an unfair advantage. And one of the big areas where we're going to see a proliferation, and you already have seen it to some extent, is customs fraud. with customs fraud. If somebody's competitor is getting cheaper product from China, evading the 25% tariff, and then landing it in the US with a drop shipping scheme, and therefore the cost of goods is cheaper than the competitor, you bet the competitor is going to be upset, and you bet the competitor is going to look for a way to neutralize the conduct and even the playing field. And the False Claims Act may be a fertile route to file that customs fraud case if the entity or individual knows about it. Another area in which competitors may get upset are kickbacks, particularly in the Medicare and Medicaid space. If all of a sudden business is being drawn away from a company because a new kid on the block, or maybe an existing kid on the block, is giving unlawful inducements to individuals to garner that business, they're paying for that business for Medicare or Medicaid, then outsiders may have a perspective about what's going on as a competitor, because when they're asking people, hey, how come you migrated from my company to the new kid on the block corp, and their existing client base or their former client base says, well, because they're offering me $1,000 per patient to go there, what are you offering me? Well, they may have visibility that there's a kickback scheme going on, and as a competitor, potentially bringing that action. In short, maybe it's already too long, but in short, if you want to find out whether or not your information is sufficient enough to bring a whistleblowing claim, you really can't rely on this video. This is just a survey of what's going on. You need to speak to a whistleblower law firm. Strongly encourage you to call our firm, Brown LLC, 877-561-0000 for a free confidential consultation. But even if it's not our firm, you're sitting on information. The information has implications. Speak to somebody who knows what they're doing to understand what your rights are, to see if you could bring a whistleblowing claim, whether you're an employee or not.